Heirs. Here we go. Welcome to Tampa Home Talk with your host, native Tampa real estate girl, Katrina Madewell, a full-time passionate, out-of-the-box thinker with love for home ownership kind of realtor with nearly 30 years of combined mortgage and real estate experience. Tune in every week at this time for expert advice on everything you need to know about home ownership, finance, maintaining great credit, building wealth, and making your everyday life better, and how you can be financially successful today and tomorrow. Remember, love where you live or let Katrina fix it. Now, here's your host of Tampa Home Talk, Katrina Madewell.
Well, good morning and welcome. This is Tampa Home Talk, and it's mid-August 2024. I'm your host, Katrina Madewell, hanging out with Leo King with Barrel Engineering and Inspections, Mr. Adam Talley with Talley Insurance.
Good morning. It's good to be back.
And we have Anthony Messina with Messina Law Group in the house. Welcome. Good morning.
Morning.
So we're going to do a little bit of the real estate rant that we do first segment, and then we're going to jump into our topic for the hour, which is why a will won't keep your heirs out of probate and what to do about it. So there's a common misconception that if you have a will, everything's all taken care of. It's easy. And you won't have to hire another attorney and go through probate if you have a will, right? You already did your estate planning. We're going to talk about why that is not the case. It's a big misconception that I see among folks when I talk to them. And we're going to give you 5 steps to take to avoid probate and set your heirs up for success. And so before we do, let's dive into our numbers for the week. And then I'm going to talk about a really big change that's effective tomorrow, which we've been talking about a little bit on the air for the last couple of weeks going into today. All right, so the number of new listings is up sharp this week. We're coming in at 909. Ooh. So a little bit more inventory compared to last week. 909 is consistent with the previous couple of weeks when we were right about that number. Last week it was low, though. It was only 769, so it was coming in a little low. We're right back where we were in the previous weeks. And the number of sold listings is coming in at 664. So that number is still a wee bit lower. And our pendings are right in the middle, 701, which means some of those people are going to go into contract. They're going to drop out, and not all of them are going to close. That's what I'm looking at in the data as I'm looking at it.
Now, do you think with the rates going down, like we talked about last week, do you anticipate that probably in the next couple of weeks you might see that sold go way high? With the new listings, now that people can get, a whole percentage point in some cases is a big deal.
We had a rate decrease, or the banks are just decreasing rates because they need sales?
It's not just the banks. Remember that the bond market moves like the stock market.
Right.
So essentially, there's been natural rate drops built into there. The feds haven't done anything. They haven't adjusted the rates.
Right.
That's basically the rate in which banks buy money. And so that hasn't happened. But the rates have ticked downward, if that makes sense. Almost a point from what I'm hearing in most cases.
Yeah,
so,
I saw my first 5.
Yes,
like 5,
you did?
7, 5. Yeah,
okay.
I saw one a week and a half ago.
That's pretty impressive.
Was there points on that?
Good.
Do you remember?
I don't think there was discount points. The lender was actually at the closing, and he said that there was some special program. The lender, the mortgage broker was at the closing, but the lender was giving some big discount. Does it once a year type of thing. It was a VA loan, so
once a year, Santa Claus.
Right.
Yeah, Santa Claus of rates.
Were the state taxes on there, or were they waived on that one? Do you remember?
No, there was.
Okay. Because I know Hometown Heroes has better rates, and then also
it wasn't a
reduced
Hometown
fees.
Hero. It was a VA, though. But
okay.
So,
it was
well,
575. It's pretty. I was like, haven't seen that in
so
a year and a half,
that may spark
2 years.
stuff, but there is a change.
in looking at this data, though, when I truly look at it, if we see the number of pendings, the number of pendings was still trending downwards and has been trending downwards since, we would say, its peak in May of this year. If we take an average of the 2 weeks, last week, which had a substantial decrease, and this week, which we seem to be back towards normal, if we average those 2 weeks because of pending staying about the same, then we're still right on par with where we've been since May.
Yeah, there's a continual drop over our high, which was around April. at 985. We had that high pending, and compared to 701, I mean, it's still less. You have to look at what's coming on the market compared to what is sold. Like, that's ultimately determines which way the market is going in terms of absorption rate. Pending is sort of your North Star. It tells you which way the market may go, but not all those will close. Your sold is your true indicator of how many are going away compared to how many are coming on the market.
So do you think next week we'll see those pendings go up a little bit?
I don't think you're going to see any radical changes this year. I just don't think you're going to see it. You might see a tiny little spike if the feds drop the rates, and that's public information. But keep in mind, this is an election year. There's also a lot of the big companies that have started laying off jobs. We're starting to see people lose jobs. So it's going to take a lot of those things, really, I think, before the feds even want to reduce the rates or modify that. I think you're going to have one, just because it's an election year, and I've said this all year, all of them are going to push to get at least one right before the election because it looks good, right, going into the campaign. So it doesn't matter what political party you are, they're all going to push for it. So they're going to push hard to encourage the feds to make at least one drop.
And I would disagree with you on the standpoint. I do believe next week we will see an increase in pendings over the average. I think when we have this many houses that have just hit the market after a week where there was a lot of houses that didn't hit the market because there was a 20% decrease week over week, I think naturally we would see higher pending numbers next week because there's the surplus of inventory will be there. So I do think we're going to see a slight spike next week in the pendings.
Try to lock in that mortgage before it gets back over 7 again.
I think we're not going to stabilize out completely and see which direction the market's going to head until next year. I think next year will be a pretty good indicator. Probably by February, we will have a really good idea which way the boat is turning, if that makes sense. I think we're going to hover and stay in a balanced market unless something crazy happens and unemployment spikes for whatever reason, COVID, a war, stuff none of us can control or see. That obviously is going to change the economy and the market and what happens with rates and housing and all that jazz. But the biggest change on the horizon right now for our industry, and this is going to shock a lot of people when you actually take that first footstep into entering to the market. So a lot of people are used to, if they see a property and they want to go look at it, they just call an agent and say, hey, I want to get in to go see 123 Main Street. Right? And you have these Pop-Tart agents that'll say, okay, sure, I'll meet you at 5 o'clock, right?
What's a Pop-Tart agent? They just pop up when you're ready? Like, what is it?
Kind of, yes. It's what we call a Pop-Tart agent, where basically someone calls, they want to see a home, they just go on out there and show the home to the buyer without any pre-qualification whatsoever. They don't know if they're a murderer. They don't know if they're pre-qualified to actually buy. They don't know if they have the credit to buy. They don't know if they have the cash to buy. They don't know anything about them. And yet they're opening up a seller's home and just letting them in, and they don't know. So I would say on the luxury ones or stuff north of 500, definitely there's more qualification that probably goes into play. But a lot of times I see it, especially on the lower end and the newer agents, would just let them in. And so as of tomorrow, that's changing. So no agent is going to be able to legally or ethically otherwise be able to unlock a door for you until you sign a representation agreement in some capacity. So we've seen everything from touring agreements to regular buyer broker agreements, which we've always had. And I think we're going to see a lot of stuff in between. So I think you're going to see agents that charge an upfront retainer, and buyers can pull off of that at an hourly rate. I think you're going to see that. I think you're going to see some flat fee buyer brokers where they say, come on down, sign the buyer broker agreement with me. I'll get you into a property for $9.95, right? So you just have to think about that and think through that, because the old adage is true. You get what you pay for, right? And so I'm going to reference over to my friend Anthony Messina and what I tell people when you need to hire an attorney for anything at all. Mm-hmm. If you hire any old attorney, guess what you're going to get?
Not great.
Any old attorney, that's what you're going to get. And so I think attorneys are a lot like real estate pros, right? You have a lot that are okay. You have some that are subpar, right? The bad apples of the group. And then you have the 20% that are the top in their profession. And they know their practice and their area of law extremely well, right? So whether it's a real estate attorney, or let's say you're hiring a defense attorney, right, for something major, a crime, murder, whatever, I don't know, but are you going to hire the cheapest attorney on the block if you're looking at going to prison? Are you? I'm
Sometimes
not.
you get a public defender. You don't have a choice.
You're correct. And I think there's always a company with a touring agreement that you could sign. So I guess that would be equivalent to a public defender. But just be careful what you get, right? And I think agents are going to have a hard time explaining this because here in Florida, we have not been sort of a mandatory buyer broker state where some places like North Carolina always have been. So they always sign the buyer broker agreement. It's nothing new for them. It's business as usual. But here in Florida and places like California, especially the busy states, the busy big cities, there's so much competition that there have to be Pop-Tart agents or they're just going to call somebody else. Right? And it happens. I've seen it on my own listings where people will say, I just want to go out there and meet you at 5. And I say, okay, well, let's talk. I need a few things from you. And then I will literally, sometimes I've had people hang up, go call another agent. They let them in without any pre-qualification. They came later with an offer. And guess what happens? I'm going to tell my seller, hey, by the way, this same buyer tried to come tour your home. They weren't qualified. They weren't approved. And essentially, this buyer's agent let them into the house without being approved. And so I tell them that. And there's been times that agents have lost their offer because of that, right? You get more than one offer. And the seller's like, well, I don't know if I want to go with someone that just opened my house without them being pre-approved.
Yeah.
So you just have to think about what you're going to get. And so all agents are not created equal any more than all buyers and sellers are created equal. I think ultimately at the end of the day, what the DOJ is trying to do is protect the consumers and give them choice and give everybody choice, buyers and sellers. However, I believe it's ultimately going to cost the consumer more, like it does with a lot of things, right? You put in regulation, it costs the consumer more. It's going to happen. I mean, we're seeing builders right now paying 8%. 8% commission. So guess what happens?
Yeah, it's interesting. I was talking to a buddy of mine who's a broker, small brokerage, and a couple weeks ago, and he was trying to kind of create a in and around on the BBA, maybe have the buyer sign a BBA at 0%, and then once they negotiate the credit from the seller, you can do an amended BBA.
No, it's illegal is what I've been told. You cannot do that.
And that's what, I said, as far as I know, maybe that works, and that's probably a loophole that they'll close eventually. But then they came out with the touring agreement, which is essentially the same thing. You sign a touring agreement with potentially 0%, go show a house, because you have to have that documentation now before you go into a house. And then maybe you make an offer, and we all know verbally there'll be that conversation between the agents. How much is the seller going to offer as far as a credit? I've seen some funny emails already with the conversations between a buyer's agent and a listing agent. Hey, how much are they going to offer? Otherwise, I'm not going to show the house, which
Can't do that.
Maybe don't put that in writing, but we know that the conversation is still going to happen, right? And then, then ultimately once there's an offer and maybe including 2.5%, 3% credit towards buyers' commissions, then they'll sign the BBA.
So, Anthony, I would add a couple of things because the touring agreement is separate from a buyer broker agreement. Mm-hmm. So what they're going to try to do is get the touring agreement signed and then upgrade them to a buyer broker agreement.
Correct.
That's the plan, right? So if you go through an open house, you're there on behalf of the seller. You're not going to have to sign this. If that agent starts giving you advice, kind of, and I'll reference our legal friends in the house, kind of like an attorney, right? Mm-hmm. You can't give legal advice until you are retained to do so. Mm-hmm. It's going to be very similar for an agent. You cannot give real estate advice until you are retained to do so. The bar is being raised, and so a lot of agents I know don't like this. A lot of people are going to be squeezed out, but the bar is being raised. The professionalism is going to have to show up.
I wonder if we might see a little dip for a few months while people figure out what the heck they're doing with all this.
We might. And I predict a couple of
complicated.
Things. I think buyers are going to go direct.
Okay.
Right, to a listing broker. Don't know if that's a good thing or a bad thing, but I think if you are... You know what? We're going to continue. This is not something I can fit into 30 seconds. So our off-air number is 813-377-2775. You can call or text if you got questions, and I know you guys will. You can call or text, and I'm happy to chat with you about this. 813-377-2775. And those of you that have listened to me for a long time, you know you can count on the truth, and I'm going to tell it to you straight. 813-377-2775. This is Tampa Home Talk. We'll be right back.
Welcome home. This is Leo Kane with Barrel Engineering and Inspection. Welcome you back to Tampa Home Talk. We're having a heated debate right now over the future of the real estate market and the way that the buyer's agents are scrambling through touring agreements. I thought we were talking about bands and venues at the beginning, but a touring agreements where an agent will let you into a house.
What is this guy at a golf tournament?
I don't know.
I know he sounds like it.
I don't know if I like the voice.
What,
you know,
Did you have a little too much of your own beer last night?
Well, no, I was watching the Little League World Olympics, Little League World Series.
World Olympics.
And I was just inspired by how these announcers can commentate baseball. So I thought I would bring some of that to the air this morning.
It's not working for you, buddy.
I vote no.
It's not working for you.
So you would rather I go back to my loud, boisterous
Yes,
animated...
anything but this.
Bring the dad jokes. That doesn't work.
Bring me a pillow if you're going to keep doing that voice so I can go to sleep.
Okay, just give me a tip of the week, Adam. Give me an insurance tip of the week.
Insurance tip of the week? Yeah, so, we had the hurricane come.
And the other one just kind of went away.
Thank goodness. As you usually say, they kind of follow each other a little bit, but that one went a little further east, which is great.
It was too far north. By the time it caught track of Debbie's wall that was created, wind wall, it just curved up towards Bermuda, which I figured it would.
Which is fantastic for us. But we need to talk about flood insurance, right? Flood insurance is not included in your homeowners, or rarely is. There are some carriers that have an add-on program.
It's required now, isn't it?
It is not required. Citizens requires it. Most carriers will require
every
it.
Policy they're requiring it now?
It's kind of going year by year. They're adding it based on the value of your home.
Okay.
Right. Now, most carriers, if you're in a high risk flood zone, that'd be anything that starts with an A as an apple or V as in Victor. They require that you have that anyways. And if you have a loan, your mortgage is going to make you have that in those zones anyways. But a lot of people don't have flood insurance. And what I tell people, we got a lot of rain during that 3-4 day period.
The Debbie Downer.
If you go outside and you had a lot of pooling, it didn't subside really quickly, stuff like that, you might want to consider getting flood insurance, right? It's a good indication that if we do get one that hits us directly, or was it Harvey that sat over Houston for 5 days? Which one was that one?
I mean, we had Gene back in 2006 that just hovered outside of West Palm Beach. We had Harvey that just kind of hovered outside of Houston. It's these hovering storms because you got to think if the storm, especially a storm where a quadrant is where the wind, because these things turn counterclockwise. So if a storm decides to stall, let's say over Sarasota, where it's over the water and not over land, we're just going to get dumped on by lots of rain. Same thing happened to West Palm with Gene. That had the southwest quadrant over it, and it was just dumping water over West Palm Beach. And it sat there for like 4 days at 3 miles per hour movement. So it was basically stationary. And you even take a look at Debbie. Once it went through the panhandle, or actually the northeast part of the state, it did that weird curve as it went into South Carolina and Georgia.
Right.
I mean, the Charlotte airport was shut down for several days over it because it was moving really slow, and then you had the whole northeast and west quadrants dumping water into South Carolina.
Right. So if you had that situation with Debbie, which wasn't really major for us, we just had a lot of water, you might want to consider flood insurance. And flood insurance is inexpensive if you're in an X zone for the most part.
It's a 30-day wait, right?
If you go with the NFIP, right, the National Flood Insurance Program, that's what's backed by FEMA, yes, you have a 30-day wait unless it's for a loan closing. We have some private market options that have a 10-day wait, so you can get it a little bit quicker.
And the other thing to think about right now is we're in the middle of August, so between now, the next 45 days is what they would say is peak hurricane season.
Correct.
We're watching what's forming off Cape Horn, off the coast of Africa. The slow-moving storms, the ice storm of the year, the Irma, the Ian, the...
it's coming.
Yeah. All these retired ice storm names, Ideala. That storm...
Idalia.
I know. I was like, what did he just say? He messed that one up.
Those storms should be forming within the next week.
Mm-hmm.
These late August storms that kind of just go across the Atlantic that hit us anytime between September 10th and September 30th, that core devastating storm, those are forming now.
Right. And 30 days puts us middle of September.
So you better look for those private carriers. 10 days.
And you don't want to wait because, as we've seen recently, those late season storms, those October storms have been more our part of the state. So be vigilant. If you have an issue with water retention, give us a call.
Yep.
Help you out.
All right. So let's just move on to our topic before we run out of time.
Yeah.
So, because we'll get a little chatty and forget to talk about this.
If you want to chat, 813-377-2775.
We'll transfer
Call
you to
or
Adam.
text. Yes, I got all day.
813-377-2775. Just text the word Adam. We'll make sure you get a piece of his ear for the next 30 minutes.
All right. So why a will won't keep your heirs out of probate and what to do about it. So this is the thing that nobody ever wants to think about. Nobody ever wants to talk about. Nobody ever technically wants to do anything about, right? Who wants to talk about death? But humans have a 100% chance of mortality. I'm just saying it's going to happen at some point. When your number is up, your number is up. And so essentially we put together 5 steps that you need to avoid probate and set your heirs up for success. Because one of the common things that we see very often is people will say, I need to get a will done. I need to get a will done so I have an estate plan. Just need to get a will done. And so it might be okay, but I would say a will is probably not your best option. And so it makes sense to talk to somebody like Anthony to help plan for these things. And so what are some of the things that you see, Anthony, when you see a client come in and someone has passed away and they say, okay, I got a will, but I don't understand why I can't sell this property, or I don't understand why I can't easily sell this car, or I don't understand why, I can't access my mother-in-law's bank account, or whoever it is that you've lost?
Sure, yeah. I think there's a lot of the problem comes with terms, right? So like you were saying, it's scary how many people think that a will just directs assets automatically. A lot of times, a will doesn't even change the default rules in the state of Florida. We know the default rules are called intestate laws. So if you die without a last will and testament, there's a set of default laws that direct your assets. There's a whole chart that you can go into, but usually it's to your kids. And if your kids don't have kids or they're predeceased, to your parents. And if your parents are predeceased, to your siblings. It goes on from there and out to cousins and whatnot. But all of that requires court supervision of the transfer of those assets. That's what a probate is. So if you have a will, you're changing the default rules to say that I want my assets to go different places than the default rules, but it still has to go through probate. So a lot of times owning a title company and working with realtors like yourself, you'll have folks, you guys will go on a listing appointment with a child of the actual record title holder and say, hey, we need to sell mom's house, we need to sell dad's house, and they're not entitled yet.
Right.
And that's when it gets kicked over to us and say, hey, we need a probate done to transfer these assets. But I do get that commonly. It's like, well, we had a will, it should already be there. No. You still need the court to enter an order, usually for a primary residence, which we see a lot. Most people, that's their big asset, is their homestead. So that would go through order determining homestead, or if it's investment property or some other property that's not the primary residence, you can have an order transferring it to the heirs or an order authorizing the sale, wherein the PR can sign the listing agreement, sign the contract, sign the closing documents.
And your PR is your personal representative for
Correct.
the estate. So let's talk about that for just a minute, and let's talk about why that even matters, because part of what the courts do, and certainly, Anthony, you can chime in on this and add some more value to the topic, but what you don't want and what the state doesn't want is, say, even if it's a piece of land, right, and there's nothing on it, they don't want that just passing to whomever. So part of the probate process is the courts actually verify the validity of the will, right? They verify, and I'm sure they have different ways of doing that. I don't know what that ins and outs are, but it's to make sure that that property is going to the correct heir. And that's part of the probate process.
Sure, yeah. So in Florida, we have some higher standards than other states. Some states, I don't know the laws of any other state besides Florida, but my understanding is there are some states where it can be on a bar napkin. Ours, they have to be notarized, they have to be witnessed, they have to be self-proving. all for that purpose of having the court make sure that this document is legitimate and this document is the decedent's intentions.
What does self-proving mean before you move on? What does that mean?
Well, so you have two witnesses, and then the witnesses' signatures, mechanically, the witnesses' signatures are also notarized.
Got it.
So it doesn't have to. You don't have to bring the witnesses in to attest to the fact that the will was signed in front of them. So it kind of makes it a little bit easier to do that.
How long does probate take?
Oh,
So-
it depends. That's $1 million question, buddy.
No, that's the number one question.
I got a follow-up question when we're back, too.
How much and how long does it take? It depends what the asset is. A homestead's going to move quicker. Technically, by Florida law, when it's a homestead, the moment the person dies, it vests in the heirs, kids' names, normally kids. But you still need that order determined homestead to prove that within the public records.
And if you have a spouse, sometimes you have a second
Spouse,
spouse
yeah, I
that's
left
not
that
the
out.
kid's parent. That can add a whole layer of dynamics that gets very dicey for families.
Oh, boy,
so,
folks.
And we see that,
Let's hope
right?
they don't
we see
die
that on
together
our
in a
side.
car accident.
So, and that happens, right? That's the point of this. So when we come back, we're going to go through the 5 steps you need to take to avoid probate and how to set your heirs up for success.
Welcome home. This is Tampa Home Talk. I'm Adam Talley with Talley Insurance. We've already covered our insurance tip
We
of the
have.
week, so we can skip right through that. Now,
Yeah.
I do have a question before we go into the 5 tips here. And, maybe you can just cover
5
it
tips to keep your heirs out of probate.
out of probate. How does it work if one of them owns a business? How does that business get transferred?
Oh,
to,
that sounds scary.
How long do we got?
You can leave me in your will for Beryl. I can handle it. I'm not an engineer, but I can manage people.
So,
Leo.
the stock and this is something that we'll go into in the tips, but the stock or the membership interest, LLC or corporation,
Right.
whatever the case is, it's an asset.
Right.
And for most people, small business owners like myself, probably yourself, everyone here, the stock or the membership interest is in your personal name.
Right.
So that has to get probated. If you have a will, that's the instruction to the court, and most people's wills say something to the effect of, I want everything to go to my kids equally or something like that. So it goes through the probate, and ultimately those shares of stock, maybe 100% for you, or if you own 50% of the company or whatever, will get transferred to your heirs, and then ultimately they'll become shareholders or members. Now,
How does the business operate in
That's-
the meantime is my question.
Yeah, so the court, once they appoint a PR, which happens earlier on in the process than the actual assets transferring over to the heirs, the PR can step into the shoes, and that's the whole point. So dead people can't sign documents,
Right.
I mean, it's the same thing with a minor. A minor doesn't have legal capacity to sign documents. That's why you need a guardian or somebody else that can sign the document for them. Dead people aren't here, so they can't sign documents. So in a probate that's more than a summary probate, which if you own a business, it's probably going to fall into that category. Right. Early on in the process, you'll get a personal representative appointed, and that personal
who is
representative,
that personal representative? Somebody within the family, or like a court-appointed third party?
Depends.
So
right?
last will and testament usually is going to identify that person. So your brother, your oldest child, something like that. It can be a third person, third party, an accountant or a trusted friend or something like that. But if you don't have a last will and testament, the default rules have a process of identifying those who are eligible to become the personal representative. Got to be over 18. We want people who live in the state, et cetera, et cetera.
So I'm going to add to that, Adam, and say if you own a business, you should have an operating agreement.
That's where I was going
And
next.
that operating agreement is going to direct traffic in your absence.
Well,
Because, for example, like you look at your firm, right? Mm-hmm. And so you're an attorney. You can't just give your firm to anybody. If they're not an attorney, they may not be able to do your job, right?
Right.
I mean, there's a lot of layers there.
That's where I was going to go to add a layer of complication. If you do have an operating agreement and you have partners, other shareholders, other members, a lot of times those operating agreements, if you had them done by a professional that knows what they're doing, a lot of times they're going to carry like an involuntary transfer provision that says, upon my passing, my partner gets to buy my heirs out for some valuation. Hopefully it's a fair one. If it's my brother, I buy him out for free. So there's usually a mechanism to liquidate the shares of stock or membership interest to turn it into cash so that, because in theory, your partners in that business, wanted to be partners with you. They didn't want to be partners with your spouse or your kids or whatnot. So there's all kinds of different possibilities there, and it depends on how that ownership interest is held. You can get around it, kind of going back to our topic here, the same way that you can do with real estate, the same way that you can do with bank accounts. You can hold your membership interest of the LLC or stock of the corporation in your trust, which is a way to avoid the probate, right? Because when you have a trust set up and you have assets put into that trust, you have this other person, the successor trustee, who is identified in that document that has immediate access to the asset. In the case of a company, has immediate ability to manage the company, doesn't have to wait for a personal representative to be appointed, doesn't have to wait for those shares of stock to be transferred to the heirs.
And when you look at that, like all of our businesses, everybody here in this room, and I know your spouses, don't have the same license that you do. Yours, mine, yours.
No.
Your wife's not an engineer. My husband's not a real estate broker. Your wife is
She
not
doesn't
an
even want to touch
agent.
insurance.
Your wife is probably not a
Yeah, I got a
attorney,
brother.
is she? Or brother?
Brother is, yeah, he's my partner.
Okay. So
we would
that's
have
different,
a
right?
way to carry on
Yes.
the firm. But
But
yeah,
a lot
for
of
us,
people, like how many times do you see people that own a business and you have a spouse that's left and they have no idea what to do with it? They're not licensed to run it, or they just don't even know how things operate.
a lot of times in that operating agreements that have that involuntary transfer provision, it's wise, especially if the business is worth something, to get life insurance that covers the one partner versus
Buyout,
the other
yeah.
one.
Yeah.
So now there's this sum of money that the surviving partner can use to buy out the decedent and get the cash to the heirs, which a lot of times that's what you're doing in the probate. You're liquidating assets down into cash and then distributing cash to the heirs.
So let's talk about the 5 steps you need to avoid probate and why they're important and how it can set your heirs up for success. And so the number one thing on that list, Adam, is evaluate your assets. So this ties right in nicely to your question. Evaluate your assets. Your business is an asset.
Yeah, and when we were speaking before off air, I didn't even think, stock or membership interest. So yeah, I mean, you should talk to somebody who knows what they're doing, a financial planner and an estate planning attorney. But step one, when we do our estate plans, we have this 20-page intake form. The hardest part sometimes is just identifying all the things. Some people it's easy because you don't have a lot. Maybe you just have a primary residence and a couple bank accounts, checking and savings. But, maybe like folks like us, small business owners, you have a lot of different things going on. You have, maybe you have a couple different corporations. Maybe you have a couple different pieces of real estate. Maybe you own a real estate in an LLC. So getting a list of all your assets and knowing how those assets are titled. So anything that is in your personal name when you pass is something that is going to get into your estate. Now, some of those, like your personal residence, you might own as husband and wife, or wife and wife, husband and husband, whatever the case is, right? 2024, but
Spouse and spouse.
yeah, spouses,
Yes,
married
spouses,
couple.
married, yes.
So
Yeah,
those
yeah,
things
partners.
have a survivorship provision on the title of the deed, so that just goes directly to your spouse when you pass. But when that spouse passes, it's gonna, and it's held in their personal name. For me, my wife, that would go into her estate and would have to be probated. Now, to get around that, you can set up a trust. You can have ladybird deeds, which is something we'll talk about. But getting a list of all those assets and knowing how they're held, stock, membership interest, is really step one, because you can't do anything to plan for the future until you know what your universe of possibilities is.
So to go back to your other question, Adam, that you had earlier, is how long will it take? And the answer to that is it depends, right? Like how many layers of assets do you have? How deep does it go? If it's something as simple as just a primary home or they own just a car, that could be pretty quick, right?
Yeah,
Depending
so-
on if someone's fighting about it and that sort of stuff.
Again, when you have the homestead, legally that transfers immediately upon the death to the heirs, usually the children or whatnot, or spouse. The spouse, it doesn't even get considered because there is that survivorship provision on the deed. But when it's going to that next layer to the kids, it happens in a blink of an eye. But as far as the public records are concerned, it's still owned by the parent, right? So that's why you need that order to determine homestead. But so you do still have to file that probate, right? But we get that order to determine homestead a lot quicker. And some of that, to complicate things even further, depends on what county we're in. Some counties move quicker than others.
And we see crazy things. Like I had a client that bought a property, her and her husband, right? Because I've been doing this forever, so it was a long time ago. They actually got a divorce, got reunited, got remarried. That, talk about a muddy chain of title, right? That can really mess things up. And he had other kids that were not their kids together.
Yeah.
So there's a lot of funky stuff that you really...
Messy.
It can be very messy. And so the number one thing is evaluate your assets. So for somebody like Anthony, if you have a 20-page intake form, that's a really good sign, because there's going to be some things on there that you're not thinking about that is going to jar your memory on things you need to talk about to set your estate plan up and your heirs to succeed.
So what about, say, elderly parents, and then they put you on the deed to the house or put you on the bank account? Does that make it any easier, or is that complicate it more?
Our attorney's laughing. Our attorney's laughing.
I want to add to that really quick, because, if Mike Fasano, Mike Wells, our friends at the tax collectors and the property appraisers are here, they're going to tell you to be careful about that, because it can actually change your homestead exemption when you go adding kids on the deed. So sometimes people try to do it, but I think you're practicing law.
I have an even better reason why not to do that a lot of times. So real estate specifically, when you inherit real estate from a parent, you get something called a stepped-up basis. So when they pass, your basis in the property is the value of the property when they pass. So then if you sell it immediately with Katrina, for $500,000, that's the same value as the fair market value when they pass. So you have no capital gains consequence there.
Gotcha.
Whereas if you're getting ready to pass, or you're older and you're thinking, well, I'll just give this house to my kid. Well, now you've gifted it to the kid, and the kid has zero basis in the property, or some much lower basis in the property, and then they go to sell it, and they get a 1099 for $500,000, and their basis is zero, or maybe they put some money into it before they sold it to clean it up, but they have a very low basis, and now they have this huge capital gains consequence. Right. And that's where the ladybird deed kind of comes into play. So rather than just outright gifting it to a child, or maybe adding on joint tenants, survivors, whatnot, the ladybird deed, you kind of get the best of both worlds. Yeah. So you get to create this survivor interest, so it passes to your kid or kids or whoever you want it to go to, without having to go through a probate, which can be expensive and time-consuming. You get that, if it's a child, you get that stepped-up basis, which is beneficial for tax purposes. And you also get the grantor, the parent usually, gets to maintain their autonomy. So an enhanced life estate deed, as opposed to a regular life estate deed, the grantor life tenant still retains all power to sell, mortgage, transfer, et cetera, or even terminate that remainder interest. So if the parent and the kid gets a little sideways, you can just give them the boot,
And what's the difference in those? What's the name of them?
So a regular life estate, not enhanced life estate deed, or sometimes enhanced life estate deed is called a ladybird deed. The regular life estate deed, once you create that remainder interest, that remainder man, even though they're not an owner of the property, they don't have the right to possess the property, they do have an interest that vests in them that can't just be taken away from them, and the property can't be sold without their signature.
Because you changed your mind.
Exactly, right. So if the grantor, again, in this scenario that we're talking about, the parent, says, hey, maybe I want to sell the house, now the kid has to sign all the stuff, because the kid has an interest in that property, even though it's not the right to possess the property, not a quote-unquote owner.
This can get so muddy. We see people mess it up. They put minors on there. Like, don't try to do any of this yourself. You're probably going to mess up the deed if you try to prepare it. Don't do any of this.
Yeah, I would say that definitely. If you, and as a realtor, I would assume you guys are going on the property appraiser and you're looking to see who the record title holder. Anytime in this, Hillsborough has like 4 or 5 deeds there, usually Pasco, Pinellas too. They usually have a couple of deeds listed. If a couple of those are quitclaim deeds,
get a title search.
It's
definitely do title search.
Or if it's prepared by the owner, at the top, quitclaim, even if it's a special warranty.
I didn't know you could FSBO.
Yeah, you can. I wouldn't recommend it.
No, you can do your own title work.
I wouldn't do it.
Well, you can. You can do it for yourself.
Yeah.
If you're not a licensed attorney, you can't do it for other people. Right. But you can do it. You can always do it for yourself. It's just how much of a mess do you create, and sometimes it creates a really bad effect for the heirs. They thought they were giving it to the one kid. Yeah. They didn't do it the right way. Now the 4 other siblings that were not in favor.
Now the jerks
still got probate.
Yeah, correct.
So we're going to talk about this. We're going to actually roll through the 5 steps when we come back in our limited amount of time. But number 1 is evaluate the assets, and we'll talk about number 2 a little bit more when we come back. But that's decide the vesting interest that might be best for you. And this is where our attorney friends can really help you understand this. 813-377-2775. 813-377-2775.
Welcome home. This is Leo Kane with Barrel Engineering and Inspection. For those of you on the YouTubes, which make sure you smash the like and subscribe button, especially the Facebook people, we have a new banner that was just put up between segments. So if you're noticing something different, you can no longer see my sexy legs. It's because we now have a banner blocking the view.
We didn't chop it up into two different shows.
We should have not debuted a banner in the middle of the show. For those in Radio Land, we appreciate you listening to us on podcast radio. Continue to tune in week to week, but you won't be able to see the banner, which does look awesome. Looks a lot like our old banner, only minus some branding.
Yeah, go on over to YouTube and check it out. All right.
Smash the like and subscribe button. Now we got 4 more tips to go through.
Well, the 5 steps to keep your heirs out of probate and how a will doesn't help you. Number 1, evaluate your assets. So talk to a pro like Anthony Messina so they can guide you and protect you through this process, making it easier, saving you time and money, and making sure it's set up correctly. Second thing is decide what vesting interest might be best for you. There's a lot of different ways to do this, right? So we talked about some of them in the last segment.
And in my opinion, this is the skill in being in estate planning. Mm-hmm. A lot of our documents, and people say, "Oh, why do you charge so much?" It's just a form, but the skill is knowing how to set up an estate plan that benefits the person looking to transfer their assets.
The skill is what saves you the time and the money later.
Right. And like we said, probates can be expensive and they can take a lot of time, and maybe in the wrong circumstances can cost you a lot of money because the assets hung up in, probate for 6 months or a year, and they can drag out longer than that if heirs are fighting, and maybe the market shifts and all of a sudden you can't sell that house for $500,000. Now you can only sell it for $350,000, so that wasn't a big issue for us a couple years ago when everything was going up like crazy, but now it really is, and the market's shifting a little bit. So it can cost you a lot of money over time. But yeah, figuring out what works best for the person that you're speaking to is the skill. If it's an individual that just has a primary residence and a bank account, maybe the enhanced life estate deed and a POD, payable on death, or a beneficiary on the bank account, depending on what your bank calls it.
That's our third step is the POD. That's a big one that I see people miss very, very often. They don't go to the bank and say, "Hey, add this person," or "Hey, add this person as payable on death," because the bankers will shun you like nothing. You're not getting into anything.
You're not an authorized signer on the account. It's the decedent's account.
PODs remind me of something. What do you call a priest who becomes a lawyer?
Do tell.
A father-in-law.
Oh, my gosh. Oh, that's a good one, Leo. Good dad joke for the hour. Very, very good. We're proud of you. Yeah. All right. Number 4. Make sure that your assets are titled the correct way. Talk about this.
And that kind of ties into the figuring out what vesting mechanism works for you. But there is in a perfect world, if you can get all your assets set up with an enhanced life estate deed or some type of survivorship, a POD, there is a perfect world where you don't even have to do a probate. And it's funny, I have an attorney friend of mine, and his mother was, pretty old, and he thought he had everything transferred into the trust. And, so for a bank account or for a piece of property, doing a deed from yourself to yourself as the trustee of the Anthony Messina Trust, and then going to the bank and changing the title of that account from Anthony Messina to Anthony Messina as trustee of the Anthony Messina Trust. Those assets are now in that trust bucket, and they will move automatically upon your passing.
And talk to an attorney about this, because trust can be pierced. You might want to have more than one entity or trust set up. There's a lot of different things you need to chat about if you have multiple assets.
Yeah, I think there's some misconceptions there too. A lot of people think that trusts provide liability protection like a corporation or an LLC. Most of the times they don't. There are things called an irrevocable trust that, if you have a more, wealthy individual that can be useful and create some, segmentation in assets and stuff like that. But most people just fall into this category that, they just need a revocable trust. Right. And the revocable trust isn't a separate entity. It just has the same social security number as the grantor for the most part. And it's more about transfer of assets upon their passing.
Yeah.
And or a lot of people set them up. For myself, I have minor kids. So if I pass away and my wife passes away, who gets immediate access to our assets, and then who's responsible for providing for our children until they get to the age of 30, because I'm not going to trust my kids at 21s because they're probably going to be like me and would have made bad decisions.
Yeah. So though I want to piggyback on that fourth step and say review and update this annually, because I think people don't do this enough. Sometimes they set it and forget it. They do it. Review it and update it annually. It's going to be really, really important. And then the fifth step that I want to leave you with is just a legacy box. So leave a legacy box. Talk about this earlier with your children so that there's no surprises. You don't want fighting after someone passes. Sit down with them. Talk to them on how and why you've divided up the heirs. Let them know what to expect upon your passing. Let them know where to find stuff.
I mean, it sounds really simple, but what do you own? Like, what's in that trust? Or if you don't have a trust set up, like, what accounts do you have? And, some people make loans to other people, and that's technically an asset. When you're holding a note as a lender, that's an asset. But if your kids don't know that, so-and-so owes you $100,000, how are they going to know, other than a check coming in the mail, how are they going to know that asset exists? And you can't move assets around, and we'll see that from time to time. We're doing a probate. We get to the finish line and they go, oh, well, what about this account? We didn't tell us about it. You didn't fill it on our 20. And I got to give credit to my brother on that. Normally I would just talk to people and then, figure out what they have. He, came up with our form and, but they'll leave stuff out. And then all of a sudden you got through the whole probate, you did the whole process, and now you have to reopen the probate because there was a bank account with, $50,000 in it that wasn't identified and wasn't, included in the probate.
What happens if you get done with probate and that shows up later? You have to amend it, or what do you do? Start a new one?
Reopen the estate, yeah. Okay. Yeah, and we have to do that from time to time as well.
So there's a lot of steps to this, as you can imagine. We're going to highly encourage you to talk to a pro that knows this stuff inside and out to save your heirs tens of, sometimes thousands of dollars later in trying to go through the probate process. It's time and money that people don't want to spend when they've already lost their loved one. So highly encourage you to set this up early.
I would say almost always, some good estate planning is going to be, a fraction of what the probate's going to cost.
Absolutely.
So, an enhanced life estate deed could be $500. The probate can be, $5,000 sometimes.
Off-air number really quick, and Leo, fly through these as fast as you can. You got about a minute. 813-377-2775.
I've got for you Barrel Project Engineering sponsoring the open house extravaganza this weekend, of the announcement for it at least. We have 4 open houses for you. We got 19211 Pelican Ridge Lane, a beautiful 4-bedroom, 3-bathroom house in the new Tampa area for $575. We got 2024 Melody Drive in Holiday, Florida. 2 bedrooms, 1-bedroom house, $210,000. We've got 19445 Sunset Bay in Land O'Lakes, also an open house, 4 bedrooms, 2 bathrooms.
How about you just call her, Texas?
One last one, 8887 Little Blue Stream Drive. This is a 5 bedrooms, 2 bathrooms, and 1/2 bathroom for $600,000. It's got a pool. It's got an open house. If you need anything about these open houses,
813-377-2775.
Love where you live, or my mommy will fix it. And we're out.